Again, appreciate your patience. I'm going to call Davis and Clifton. Actually, I don't see anyone. Oh, I do see.
I'm here.
Yeah. And Cody Clifton. Is Cody Clifton present? Not seeing anyone and not hearing a response. This is a review for compliance with GAL. If the packets have been returned and any payments. Good morning, Ms. Height. How are you?
Good morning, Your Honor.
Where are we at in this case?
Well, I was appointed. I sent out packets. I received packet back from Mom. I believe this is a county pay case, so I don't. Yes, it is. So there's been no payment, naturally. I did meet with Mom. I've received nothing back from Dad, and in fact, I had quite a difficulty getting any kind of contact information for him. There was nothing on my orders. And I finally got an address from Ms. Powers, I believe it was, and sent the packet back to Minnesota. I haven't received anything back. I have no way to contact him. My understanding is from talking with Mom and visiting with Carson that they have occasional unscheduled video contact through some kind of social media, but that she herself does not have a phone number for him. She did indicate that she had asked him a couple of times to contact me and was going to pass on my contact information, but so far I have nothing. So not much to report here. I would just say that I would like to share a concern that Ms. Davis voiced to me and that I also am concerned about. Dad kind of comes and goes in and out and has told the court a couple of times he's going to be in town and then he's not. Her concern is that because of such a little bit of contact and no stable local housing, that if he had a contact or picked up Carson, she wouldn't know what to do or how to get him back if he chose to take him off to Minnesota. Nobody has said that. I'm not making any kind of accusation, but there is a concern that it could turn out to be something that would be difficult and complicated. So until some stability can be verified, I would really prefer that Carson only have video contact of the nature that he's had with his dad up until this time. I'm concerned that an unsupervised visit might turn into something difficult.
All right. And it looks like, and I guess I'd ask anyone to correct me if I'm wrong, but when I reviewed the online file, it appears as though Ms. Davis filed a motion for temporary orders, including a temporary parenting plan, and the commissioner only orally made a ruling on visitation, but didn't file anything. Is that correct?
I could not find anything else, Your Honor.
All right. Well, that's unfortunate because that's not enforceable. So we'll have to, let me see here. Let's see. Ms. Davis, the parenting plans, you filed a proposed parenting plan back in April, it looks like, of this year. And it essentially says that Mr. Clifton should only have supervised contact, in-person supervised contact for a few hours every week. You were requesting him to go do an evaluation for substance abuse and anger management, that you have sole decision making, that you're the primary custodian. Anything from that plan that you submitted in April that that you would not be in agreement with at this point or would want to change?
Instead of, because I think I asked for UAs before visits as well, and I talked to Ann about doing a hair follicle test for him if he was to come back and do visits supervised. And I think I put in there that family would be supervised, but I think we talked about doing like professionally, because family no longer wants to be part of that.
Okay. All right. And your residence is the one in Castle Rock, is that correct?
Correct, yes.
Okay. All right. So what I'm going to do is I'm going to draft a parenting plan. That will be a temporary parenting plan that's proposed by you. I'm going to mirror everything that you've indicated. At this point, I'm going to, let me see here. I'm going to reserve on domestic violence. I don't have enough information about that. And I'm going to reserve on substance abuse, but I will enter the abandonment and neglect. So that's based off what I've reviewed that's been filed. So there will be a 191 finding for abandonment, and I will reserve on the others. I will require that it's professionally supervised contact in person. And then are you okay with the, I guess, Skyping, FaceTiming, like those kind of communications are okay?
Yes.
Okay. I'm going to keep the supervised, professional supervised contact at 2 hours a week, as you suggested. I'm not going to order any evaluations at this point in time. I will indicate that you are to be the limited decision maker, so just you. And as far as dispute resolution, go to court without having to seek mediation. Custodian will be you at this point. And I will, instead of doing that right now, I will draft it when we're done here. And I will enter that as a temporary parenting plan. So that gives you, since we haven't gotten a response from Mr. Clifton, it does appear that he was present at a recent hearing, but he's not filed any responses that I am seeing. And I do see he was ordered a UA. I don't see that. Well, it looks like I apologize. He did file the UA results, which were a mixed bag of positive and negative. But it doesn't look like he's filed really anything else. So based on those UAs, I will make the finding for a hair follicle if he does show up for in-person visitations. And I'll include substance abuse as part of the 191 factor. So I won't reserve. So I'll make a finding of abandonment and substance abuse, reserve on all others, require hair follicle if he shows up for in-person. And then I'm going to file that this morning as soon as I can after the docket. That will allow you to get a copy of that to have with you. So if something were to happen, you have something that shows you are primary custodian. These are the ground rules for everything. And I understand Ms. Height's position. We're not assuming Mr. Clifton is going to do something nefarious, but frankly, I think it's really important to have at least something outlining where the child is supposed to be and kind of the parameters around what's going on with that child. So I will get that entered for you today. I would think that either later this afternoon or tomorrow, you'd be able to go to the clerk's office, get a copy of that for yourself.
Thank you so much.
My pleasure, Ms. Davis. And then Ms. Powers, I see that you're also involved in this case. Is there anything that you need or want to have happen today?
No, I was hoping maybe the father would appear and give us some updated contact information. We're trying to get child support going, but locating him has been the biggest barrier.
Okay. And I see an iPhone. We don't, just want to confirm that's not Cody Clifton. *6 to unmute on an iPhone.
Your
Okay.
Honor, if I
Yes.
might just have one more moment,
Sure.
final report is due toward the end of October on this, and I typically don't like to get underway seriously until I get information from both parties. But my plan now, after not seeing Mr. Clifton this morning, is just to continue with what will at this point be a pretty one-sided investigation, so that this case can move forward. I will tell you that my contact with Carson was very pleasant, even delightful. He's doing really, really well.
Good. I'm glad to hear that. And I appreciate that you can only do what you can do with the folks that are willing to work with you. So we'll leave the next review, Ms. Davis, for October 26, 2023 at 9 a.m. If any issues arise between now and then, you obviously are free to file a motion to be before the court. And otherwise, I appreciate your participation in the GAL investigation, and I'll get that order entered for you today. We're on
Okay,
for
thank you so much. I appreciate
presentation
everything.
of an
All right, thank
order.
you.
Yes, ma'am.
Yes.
All right, so it looks like I have both Ms. Watts and Mr. Lovato. So you see the adequate cause was found and granted on the 3rd. It looks like Judge Evans, who was handling that docket, signed off on that order, granting adequate cause. I don't see anything else that's been filed since then. It looks like petition to change parenting plan or custody will go for review on 8/10/23 at 9 o'clock. So I guess coming into this after that decision's made, looks like the motion was made the beginning of July, was heard on the 3rd of August. What are the parties' positions on this, since I haven't received any additional filings at this point? I'll start with Ms. Watts.
Yeah, so we were supposed to well, the judge wanted us to come up with because for our youngest daughter was supposed to stay with Brandon for an extra couple months just to see like how her behavior is there versus with me. And if it's better, then we were going to let her continue the school year with him. If not, she was supposed to just come back with me. But the other two, our older two daughters, are supposed to live with me full time during the year and then be with him in the summer. We're supposed to, like, I guess, fill out another parenting plan and submit that. But I guess it's just been hard because I've been on vacation. He was on vacation. And we just haven't been able to fill out anything so far as to submit it.
Mr. Lovato, does that sound about accurate?
For the most part, it's accurate. The only thing that I didn't want to have happen was Kaylee getting removed in the middle of the school year again.
Is that the youngest one?
Yes.
Okay.
Yes.
And how is she doing I'm assuming still in your care at this point?
Yes, she is, and she's been doing incredibly better. She still has like her every once in a while she'll have outbursts with her sisters, but she's a lot happier. She's been having no issues at all.
Okay. Ms. Watts, you agree with that?
So my only concern is the last couple of times I've talked to her, she's actually said, Mom, I don't want to stay with Daddy. I want to come back with you. Please don't let me stay here. And then Brandon's actually been in the room while she's saying that and he's like, well, yes, you are. And then she would say, well, Dad, I'm not staying here. I'm not staying here. I want to go to Mom. So that's the only thing that's really kind of got me like, I don't know if that's going to be the best option for her or not, because she is actively saying she doesn't want to be there.
Okay. And when does school, it sounds like you live in different areas. So when does school start in each of your areas?
So here in Washington, ours starts in, the end of August, I think the 30th.
Okay. And Mr. Lovato?
And that was the reason why we had this court date kind of rushed, is because school starts here yesterday.
And so has she
and
started?
I can't, yeah, I can't enroll her without, down here in Oxford, I can't enroll her in school without having any kind of paperwork showing that she's living with me.
Okay. And Oxford, California?
Oxford, Alabama.
Alabama. Oh, a lot further than I thought. Okay. Well, I guess here's where I'm at. I reviewed the case. It sounds like the two of you are willing to work with one another regarding the kids. Do you want, if I set this over 1 week, do you think you'd be able to submit a parenting plan, either agreed or each of you propose your own, and we review this next week so we don't delay it any further?
Yes, I should be able to.
Yeah, that should be no issue.
Okay. I guess I'm more than happy to make the decision, but I'd rather, if you folks are able to work together and kind of have a history and are trying to work this out, frankly, your decision could very well be better than mine because you know all the moving parts. And I want to give you the opportunity. If that doesn't work out, then next week I'm happy to make a decision. So let's set this to right here, the 17th of August, 9 o'clock in the morning. File your proposed parenting plans with the court. If it's an agreed one, great. If it's not, just each of you file your own, along with any other documentation that you feel is appropriate. Make sure the other party gets a copy of everything, and then we'll review this August 17th at 9 a.m.
And for us receiving a copy, is it going to be, just want to make sure it's going to be okay for us to email it to each other, since it's.
Ms. Watts, are you okay with that?
Yes.
All right. As long as you're both okay with receiving it that way and having that be considered service, then I'm fine with that as well.
Okay, thank you, ma'am.
All right. So next week, the 17th, All right. 9 a.m. Good morning,
good
Mr.
morning,
Mudge.
ma'am.
All right. Thank you. Good luck.
Morning.
And see, Miss Morgan is on this case as well. We have Miss Powers. It still says Miss Morgan in Odyssey, which is frustrating. So I apologize. This is on for Readiness, or pre-trial management right before Readiness. I don't see Miss Canaday. I don't know if she was here the last, looks like she was here when the state was set.
Yeah, she was.
Mr. Mudge, are you prepared to move to Readiness? Any concerns, discovery issues, anything that you haven't received that you need in order to go to trial?
I mean, nothing that I'm aware of. No, ma'am.
Okay. Miss Powers?
The state is ready to go.
All right. We are, looks like it's set for a 1-day trial for the week of the 15th. We have Readiness, or excuse me, the week of the
21st.
21st. Readiness is on the 15th at 11:30. And all parties.
I just do have one question for Miss Powers.
Sure.
So I understand the state was not wanting to recognize my business expenses for my travel and paying for parking because I work in the Portland area and I live in Longview. What documentation would need to be required for them to recognize that?
It's whatever documentation you want to provide the court.
Okay.
Our office doesn't recognize those unless you're self-employed. But if you want to present them to the court, you can ask the court to consider them.
Okay. All right. Thank you.
Yep.
All right. So Readiness 11:30 on the 15th.
Thanks.
All right. Thank you.
Thank you.